There is the question of being reliable, and when I do that, I get senior counsel to be here, as reliable as his column is, to bring information and clarity every week. So too is his word that he will be available as he is now. Senior counsel Martin Daly, good morning to you, sir. How are you?
Good morning, Rennie. Thank you for the compliment on reliability. You run a good, well-prepared program, so you deserve it.
Oh, well, I thank you very much, sir. You are also a source of elucidation, edification, a nice way of lifting our spirits this morning and giving us clarity. I read your column this morning, and it falls into something that you and I just briefly talked about for this Sunday. This has to do with the SSA Act. It had to do with the assenting on behalf of the president and the statement that came out of his office as to why there was a delay. There are some areas inside of there that I found troubling, and when I read your article this morning, your column this morning, it made it even clearer that yes, my angst was not misplaced. I did not understand, and you would make clear for our listeners, I ask of you, the right of the president to agree to the legislation or to not agree to the legislation. I mean, what does the Constitution say? It says that the the Parliament is going to send something to him, and after that is done, does he have the right to sit on it and contemplate and get legal advice and so on, or is there a misreading of the role of the president in this case under our Constitution?
Well, no, I think a lot of people, I know, a lot of commentators I notice are confusing delay with refusal. So let's dissect it. Let's keep the two things separate.
Mm-hmm.
As I and other commentators have made plain, in the matter of assenting or withholding assent, the president does not have any discretion. He does not have any unfettered power of his own because of the clarity of Section 80, which governs the president's function.
Mm-hmm.
And that, I think, is crystal clear. I mean, we've had commentators more eminent than myself making that plain very promptly. And the general consensus among the constitutional experts is he doesn't have any such power of refusal.
Mm-hmm.
But I notice now that people are confusing delay with refusal.
Mm-hmm.
Now, the president, in my view, has two distinct ways of operating, if I can put it like that. He has the powers that are given to him by the Constitution, and yes, there are powers which the Constitution expressly says that he must exercise either on consultation or on, in some occasions, up in his own discretion. And the obvious example is the appointing of independent senators as a matter of his complete discretion.
Mm-hmm.
So he does have legal powers, but those legal powers mostly deal with appointments. And those legal powers were put in the Constitution, and he was given that discretion, really to be a check on balance against, if I can put it this way, the over-politicization of important appointments.
Mm-hmm.
The other area where the president operates is what is generally called moral suasion. In other words, I don't have a right to tell you what to do, but because of the gravitas, the importance of my office, I might say to you, well, I like to speak colloquially, I might say to you, Rennie boy, you sure you really want to do that?
Mm-hmm.
And you may say, yes, I'm going to do it, or I'm not going to do it. And I'll say, well, Rennie boy, I'd just like you to consider this, that, or the other.
Mm-hmm.
And maybe you need a few days to think it over. And I don't have a problem if a president wants to try and exercise moral suasion, something he's uncomfortable about, asking the government or the cabinet, well, I want you to think over these points. Take a few days and think over these points. That's quite a different thing. And, of course, that delay cannot be excessive.
Mm-hmm.
It's a matter of days or hours, depending on how important it is to the government to go on with the action they do. So I see a lot of people are talking about Robinson. The point about Robinson is, as stiff-backed as he could sometimes be, when he was holding up Pandey on a number of things, in the end, he yielded. At no stage did Robinson try to exercise to the nth degree some power of refusal. He delayed, and maybe he delayed a little long and caused some anxiety. For example, in his view, he didn't like the idea of losing candidates becoming senators, and he tried to use moral suasion. And he delayed a bit to see if he could persuade the government to change their mind, but when they didn't, he gave in.
Mm-hmm.
So delay is a quite different thing, and delay must be sparingly used. And there are many other examples of the importance of the office of president outside his legal powers. Sometimes the president is used as a sounding board or as someone to whom, at a very high level, you can take a grievance and he could try and mediate. For example, many years ago, when the judges had a problem, and quite going back in Eric Williams' time, when the judges had a problem about lack of revision of their salaries, they asked the president if they couldn't, of course, go to the executive, the judiciary and the executive couldn't have a negotiation, but they went to the president and said, look, we have this problem. Would you mind on the weekly visits or whenever you have these visits, would you mind raising this on behalf and see if you can do anything for us? And that's another example of moral suasion.
Moral suasion.
So I think we have to keep these things very separate. But on the giving or withholding of assent, he has no discretion.
Well, this is where I'm confused, Senior Counsel, because when I look at the release said, in every bill to be assented, there is always a need for cause for pause. Assenting to a bill can neither be preemptive or instanter, adding that it is often dependent upon his consultation and receipt of legal advice.
No.
Now, this is the release that came from the president.
That is wrong. That can't be the norm. There may be exceptional cases in which he may want to suggest a modest delay while any points he raises are considered. But the idea that he can go out and get a better opinion than the parliament and so on, all of that is quite wrong. And he's misdirecting himself. It can't be in every case. There are some rare cases. Section 34 is a good example, where there was a lot of consternation about how the immunity got slipped in. People were feeling it got slipped in and it wasn't properly debated and so on. In a case like that, he may have a brief cause for pause and ask the executive to explain how did this thing get slipped in at the 11th hour. And after that, he has to assent. So this idea that in every case he must canvass opinion and get legal opinion, he can't get some legal opinion that overrides the will of Parliament. That's anti-democratic, and all of that is wrong.
Let us just be sure we're really clear here. So even after he may be disquieted about something in the bill, even after he contemplates, even after he seeks advice from his legal advisors, and he disagrees, are you saying he still has to assent to it?
Yes,
he still does.
He does not have that discretion under the Constitution. And he ought not, as a matter of routine, be going to have consultations and legal advice, because any legal advice he receives can't override the will of Parliament, whether expressed in a simple majority or a special majority. If it's a serious enough case and he feels to get an opinion and show the government and the executive and ask them to reconsider on this basis, he might do so. But that can't be routine way of going about this business of assenting and withholding assent. You can have a modest delay in an exceptional case. It cannot be routine. That is a rewriting of the Constitution and is anti-democratic.
And I'm very glad that you make that very clear, Counsel, because, it is disturbing for us to have the highest, to have the President Office misunderstanding the statements made when they make reference, for instance, to Section 61, misunderstanding the Constitution, because when reference is made to Section 61, that speaks of his right to withhold his assent, it was contradicted, as you said, by good legal minds. The opposition leader, Kamala Bissessa, corrected what she states was a statement, an opinion given by Chief Justice Michael de Labastide, not an opinion, rather.
She was wise to quote de Labastide rather than rely on her own point of view. Very wise move.
Very wise move. Former Chief Justice Michael de Labastide made it very clear that 61 operates in concert with 80. Make clear to our listeners, what is that? What are they speaking of?
Because 61 simply says you can give or withhold, the president can give or withhold assent. But 80 is an omnibus section that deals exclusively with the president's functions. And it says, paraphrasing it, in the exercise of his functions under the Constitution, unless the Constitution or some other law says otherwise, he is to exercise his functions on the advice of the Cabinet or a minister authorized by the Cabinet. And then it goes on to say, list the occasions on which he may act in his own discretion, or there are other parts of the Constitution that say Never mind, you're supposed to act on the advice of cabinet. When you come to appointing independent senators, you act in your own discretion. The Constitution says so. You had Mr. West on earlier this morning, and Mr. West told you that he's appointed by the president on the joint recommendation of the prime minister and the leader of the opposition. So that's an example of the law saying different from the normal rule that he must act on the advice of cabinet. But when you see president in the Constitution, at first blush, it usually means president on the advice of the cabinet, unless there's some specific law, police complaints authority being an example of which you heard this morning, that says he must do it some way other than on the advice of cabinet.
You see, I am so happy that you're making this all clear for us, because there was a statement made some time ago that the president has powers that even he does not know. I think that, and I am totally lost. I am totally lost on that. But whenever I see these things creeping in, I'm going like, okay, is there another power we didn't know about? Speak to that, please, sir.
I wouldn't comment on that. It's been the butt of some fairly fierce jokes and so on. I just think that, you see, no, mind you, I understand how people in high office can get drawn into difficulty because people give them a lot of basket when it suits them, you know, and so now because people are unhappy about various things and they don't like what appears to many people to be the excessive power of any sitting government, they say, well, we will go to the president, and somehow then they get him drawn into it. Yes, he must listen and he must explain the limitations of his office, but I can see how high officials get drawn into these things because people put a very seductive case to them, and sometimes, you know, well, some people like to be liked, or they just think they're doing good, but that is an office that must operate strictly according to the Constitution. And if you need legal advice, go out and get it.
And that is why I'm so disturbed,
Counsel. The idea that it's going to cost you a fortune. I can say I don't like to give my examples, but in the past, many presidents have asked me either to come and see them over the telephone what I think about something. My opinion doesn't bind them. And of course, I don't send them a bill. Happy to do it from a country and happy that the office of the president would consider my advice worth taking. So good advice is a phone call away, and unless all lawyers, I don't think all lawyers have become completely greedy. Many of them have, but I don't think all lawyers have become. Good advice is a phone call away. I don't want him to call me, but good advice is a phone call away. I remember on one occasion I was called and asked for advice, and the president who called me did the exact opposite of what I told him was within his powers, and I had to disassociate myself from it because people, of course, knew that I'd been to the president's house around the time.
He was ill advised on this press release. I assume that he saw everything in this press release because it is rather disturbing, quite disquieting that a release coming from the president's office would so erroneously misinterpret the Constitution according to the way you have explained it this morning.
Well, I don't know. You see, that's another thing, huh? Another difficulty, I'm coming off the presidency now, but another difficulty office holders have in Trinidad is that, there is an oligarchy. I don't know if it's parasitic, like Mr. Pandey said, but there is an oligarchy, and the oligarchy itself tends to make itself into a kind of celebrity entourage and start, trying to influence things in a certain direction. And you have to be able to resist that. I remember once having to deal with a very high official, and every time because I was mandated to do so, and every time I called, I had to give my name to 3 different people. And in the end, I said to the high official, we have to do business, and if I have to go through 3 people every time I have to speak to you, I just want to do business. And of course, he gave me a cell phone. But that's an example of the protective wall, and sometimes the advisors themselves get a little carried away. And when you're in high office, you have to have the moral fiber to resist all those things.